that is the mandatory laws in the sexual health, a mandate for all the clinicians, by Dr. Manish Machave, sir. Dr. Manish Machave, sir, is a gynecologist in Kothurud, practicing since last 20 years at Machave Hospital in Kothurud, Pune. He's completed his MBBS from BJ Medical College, Pune, and MD Obstetrics and Gynec from Pune, and also the DNB. He's the member of Pune OBGYN Society, IMA Pune, then Foxy, and also is working for the Indian Association of Gynecological Endoscopic Centers and Indian Society for Assisted Reproduction. Sir has been awarded by Dr. Kaminira Oration Award in 2013 and Dr. Indira Bai Khare Oration Award in 2013. And for all the gynecologists, he is presently the chairperson of Foxy Ethics and Medical Committee from 2020 to 24. And he was elected unopposed. And at present, he is contesting for the managing committee member of Indian Association of Gynecological Endoscopy. All the best, sir, and please continue with your talk.
Thank you. Am I heard properly?
Yes, sir.
Yeah, okay. So at the outset, let me thank Nashik OBGYN Society and Dr. Nilesh, Dr. Kavita and entire team for allowing me to speak on a little different topic this time. More or less, when we talk about medical legal issues, yeah.
So this webinar has been conducted by IMA Nasik.
Yeah, I am.
Yeah.
Most of the times when we talk about medical legal issues, we talk about issues related directly to doctors. But this is something, very nice program. I've been hearing talk since morning. I heard Dr. Prasanna, then Dr. Shantanu Abhyankar, and now also Sir on cybercrime and cyber laws. Amazing topic, very nice discussions. I'm going to discuss, something a little different, some laws. I may not go into details, but that will definitely help us increase our knowledge. So this is my first slide always. I pray to Lord Ganesh to sail me through this presentation. Thank you for a nice introduction. Again, thanks to Indian Medical Association, Nashik, Dr. Kavita Gadekar, Dr. Nilesh Jejurkar, and everybody. Dr. Singh also finished her LLB. I did my LLB from ILS and was a faculty at Indian Law School, ILS Law College for almost 2 years. Right. So the first point which I want everybody to understand is a very important Latin, saying or a dictum is ignorance of law is no excuse. That means that if you do not know a particular law, you cannot put it as a defense that, okay, this law says or mandates me to do something and I did not know or I do not know this law and that is my defense, and that is never accepted as a defense. And I'll repeat this sentence once we discuss an act called POXO Act. So please remember, ignorance of law is no excuse. Ignorantia juris non excuse. Right. So laws governing sexual health, and there are so many. I mean, to put into one presentation all the laws in details is an impossible task, but I'll try and cover most of them. Obviously, whenever we talk about sexual offenses, sexual violence, the first thing which comes to our mind is the Indian Penal Code. This is the act which tells us about crimes, offenses, and gives punishment to different crimes and offenses. So the Indian Penal Code section 354, it criminalizes any act by any person who uses criminal force or assaults a woman. So from here it starts, and this is with intention and knowledge that it will outrage her modesty, and it is that person is liable for 2 years imprisonment and fine. And Indian courts have very clearly said that the lady or a girl being a girl, that means her sex itself gives her the modesty that is being outraged. So there is no other proof needed for section 354 to be applicable to a man. Also, then there is sexual harassment in section 354A, which says any physical contact or advances involving unwelcome and explicit sexual overtures or a demand for sexual flavors. It entails, it becomes a very important ingredient for section 354A. And this is in addition to other laws. So there's another law which is prevention and prohibition of sexual harassment at workplace. that we will discuss a little later. But this is in addition to what is given in that act, which is an entire act which came in force in 2013. And what is the punishment for this? It's 3 years and fine. And if it could be simple or rigorous. And assault or criminal force with the intent to disrobe the modesty is in section 354B, which is again 3 to 7 years and fine. It sounds similar, but here of others, or even if there's nobody there, even if he's alone there, and then this section is attracted, and which is 3 to 7 years plus fine. What is voyeurism? That is what is a man watching or capturing the image of a woman, or a perpetrator on the instructions of a person is doing the same. It is 354C section, and it is punished with 1 to 3 years plus fine. Repeated offences in this instance are punished with 3 to 7 years and fine. What is stalking? Section 354D defines stalking, and it includes continuous following or contacting a woman. And it also includes if you try to follow somebody over email, social media. We just heard a fantastic lecture on cybercrime just now. What is the punishment? It's 3 years, and for repeated offenders is up to 5 years and fine. What is not a crime? So if somebody, a investigating officer or somebody who's on a legal duty is doing this, then it will not be crime because it is protected. The protection is given by state, because here it is done for a reasonable job or a justified need. What is human trafficking? We will discuss again. There is an act called Immoral Traffic Prohibition and Prevention Act, but in section 370 of Indian Penal Code, this is given, and the act is, a very elaborate act, and we'll discuss it a little later. And this involves prostitution and commercial sex industry. Rape, we all know the definition of rape was completely changed after the Nirbhaya case when Criminal Law Amendment Act came into force, and section 375 was modified. And now penetration of a man's sexual organ is no longer needed. In inserting any object, manipulating any body part, or applying mouth to the woman's vagina, urethra, or anus can also constitute rape. The consent also about this changed because the circumstances which were used were extended against her will, without her consent, with her consent if it is obtained by fear of death, with her consent if she believes that the engaging person is her husband, if she is of unsound mind, if the consent of the woman is below the age of 18 years, it is obviously invalid, and when the woman is unable to communicate consent. So the definition of rape got widened by Criminal Law Amendment Act, which came in 2013. Important things also emerged from various decisions. Physical injuries are now no longer needed to prove that there was rape. Medical procedures or interventions do not constitute rape. Marital rape is also there. And we will also discuss Domestic Violence Act, which covers marital rape too. And very clearly the court has stated that less than 18 years. So before it was 16 years and now it is made 18 years. So you all also please understand that less than 18 years, any consent with respect to any sexual thing is invalid. Then there is also aggravated rape where, there are certain situations. For example, if a patient is admitted in a hospital, or a pregnant woman, or a mentally ill woman, or if there are famines and disasters, and then if there is rape by somebody who has a custody of a female, it's aggravated rape, and then the punishment could be 7 years to life imprisonment. And after the Criminal Law Amendment Act, it came to almost 10 years. In certain situations where the female is made vegetative, it is 20 years. Now, unfortunately, this came long, after the Aruna Shanbag thing. Otherwise, the perpetrator of Aruna Shanbag, who now roams free in his village, would have got 20 years imprisonment or even a death sentence. The Supreme Court even defined persistent vegetative state as a state where the victim is alive but not aware of the environment around her. Right, then there's section 294. Long ago, there was a movie released called Tridev, and there was a song called Oye Oye, and a lot of boys, Eve teasers started using this song in obscene manner in public places, and this is then they would get this section attracted. It is section 294 of the Indian Penal Code, obscene acts and songs. Whoever to the annoyance of others in a public place sings, recites, or utters any obscene song, then it is 3 months imprisonment and fine. So all these are sections of Indian Penal Code where sexual violence, sexual offences, or sexual remarks are put. Then you have something called as a POXO Act, and you have to understand about POXO Act because, as I told you, ignorance of law is no excuse. And we have to know about this act. It is Prevention of Children from Sexual Offences. It is not POSCO, it is POXO Act, Prevention of Children. So please remember that what we have to know is our role. We have to know that there's something called as compulsory reporting, and we have to also know about examination of victim. There are alarming statistics why this act came up. There are various sections in the Indian Penal Code already which I have discussed. Why there was a need to get the Prevention of Children from Sexual Offences Act as a different act. And there are alarming statistics. 1 out of every 10 women reported some kind of sexual abuse during childhood. 1 out of 4 girls is sexually abused before the age of 4. 19% are abused between 4 and 8. Almost 35% are abused before the age of commercial sex workers between the age of 5 and 15. They form 40% of total population of commercial sex workers. 80% are found in metros. 5 lakh children are forced into this trade every year. So these are very alarming statistics. So although, as I said, rape, kidnapping, molestation, sexual harassment, everything is there in the Indian Penal Code, but still our government thought that we have to have another act for children because the earlier sections or the earlier acts are not enough to address sexual offenses. And this is, a gender neutral law. So the IPC, if you read it, always says by a man on a woman, whereas here the children, male children are also included. So it is a gender neutral act. It provides protection to all children from offenses of sexual assault, sexual harassment, and even pornography. And child here, any child who's less than 18 years comes under the POXO Act. There are special courts, there are special public prosecutors, there are offenses, there's mandatory reporting, there are procedures to be followed, and there is rule of national and state commission for children. There's provision of compensation in this act. Very important part about this act is abetment and attempt are treated at the same level. So there is same gravity of commission. So trafficking of children for sexual purposes also covered under abetment. Attempt to commit any offense is penalized with half the punishment. So, abetment and attempt are given the same level in this act. Now, this is something which all of us, all doctors, especially two categories of who have to remember that there is something called as mandatory reporting under this act. Now, what is this? Now, Section 19, I will read it for you. Section 19 of the POXO Act says any person. Now, this is a liability or a duty cast on everybody in India. Any person, including the child, who has apprehension that an offense under this act is likely to have been committed or has knowledge that offense has been committed shall provide this information to Special Juvenile Police Unit, and if it does not exist, to the nearest local police station. Which means that if in a pediatric practice or a general practice, if you see a child who has, it's a girl or a boy who has marks around the anus, injuries around the anus, or marks of maybe nails around the anus, and you suspect that it could be a sexual abuse, you have to compulsorily, mandatorily inform the police. Second, if you find any girl who's less than 18 years and who's pregnant, you have to mandatorily report it to the police. And the police will have to then investigate under the POXO Act. So please, apprehension and knowledge. So if the girl is less than 18 and pregnant, obviously you have a knowledge. If somebody has fallen down during playing or whatever the history, but if there are marks around the vulva or marks around the anus and you have apprehension that this could be sexually related, you have to inform, and it is mandatory. Once you inform under Section 154, the police will make an FIR and start investigating the case. I will skip the FIR section. The only thing which we always want that our name should not come on FIR. So there are some practical issues. If the patient is present in front of you, inform the police, call them, let the police come to your hospital or clinic, and then the person bringing that child will become the informant, and your job is over. If the patient is not present, you have to write all the details on your letterhead and send the letterhead to the police. In case the police do not file any FIR or the police refuse to take it, you have to make a private complaint. How to make a private complaint? Either in a court of session, or you can call the superior police officer. If he doesn't listen, then in a court of special session or a special court, you can make a complaint. Private complaint can be filed anybody, by a public servant, by a friend, relative, and you have to write there that the police was contacted, but either they refused or they did not take any cognizance. Now, this is important. What happens if you do not mandatorily report? And this has happened to quite a few of our IMA members. If you do not mandatorily report, then failure to report commission of an offense is punishable with imprisonment up to 6 months and fine. And this is a cognizable non-bailable offense. That means you get arrested for not reporting, and you do not get bail as the right. And somebody who's in charge of a company or an institution, for example, medical director or superintendent of a hospital, will also be punishable for 1 year imprisonment and fine. So this section 21 mandates that we have to report all these cases. Also, it can happen that somebody who's 17 or 16 comes and says, no, I am married. Let the police investigate. Less than 18 years, if you have apprehension or knowledge, you have to report. And there is no civil or criminal liability upon you for giving information in good faith. So the relatives of the boy or the girl cannot sue you or do any complaint that why did you report. In fact, you have to report, and that is mandatory reporting. So that is one thing we have to know about the POXO Act. Second is medical examination of victim. This is very important. In case of a girl child, medical examination has to be done by lady RMP. Now, if you are an orthopedic surgeon or ophthalmologist, you cannot shy away from your responsibility saying that I do not know how to do this, because you are a registered medical practitioner under the Maharashtra Medical Council or Indian Medical Council Act. Your name is there in the register as a registered medical practitioner, and a lady doctor cannot refuse. Earlier we used to send these patients to civil hospital or government medical college. Now lady RMP has to do it. A male RMP can, if there is absence of a lady RMP, can call a lady RMP, or if lady RMP is not available, give primary treatment and send the boy or a girl. But a lady RMP has to do it. She has no option. Medical examination in the presence of parents, presence of a woman nominated by the head of the medical institution. In case lady RMP is not there, can also be done. What else can be done? It has to be done in the presence of parent and guardian. Emergency medical care has to be given. No medical practitioner, hospital, or medical facility can refuse giving a emergency medical care. And there is no need to get a chit from the police or magistrate or anyone. You have to give care. So primary medical care has to be given. And what is that care? You have to treat the cuts and bruises. If there are any, treatment of exposure to STDs has to be given. HIV prophylaxis has to be given. Possible pregnancy and emergency contraceptives have to be discussed. Whenever necessary, a referral or consultation for a mental or psychological health and counseling has to be arranged. Obviously, you have to collect forensic evidence. So for that, we all need to get trained. Maybe at some another webinar, we will discuss how to collect forensic evidence. As I told you, a lady RMP cannot refuse all this. So all the ladies sitting here, out of all the attendees, please, you are RMPs, you cannot refuse. Emergency medical care as well as medical examination has to be given. Now, how do we? There are times when I get calls a lot of times that the police are not taking the complaint. The police don't know what POXO is. What can be done as society and groups? You have to give, whenever you visit your police station or whoever is going from your side, please take a copy of POXO Act and give it to the police. And please also remember, it is not the age of the patient on the day when she comes to you. You have to go back. So, for example, yesterday I saw a patient who was 18 years and 5 months old, but she had a 26 weeks pregnancy. That means around 6.5 months pregnancy. That means that the day of intercourse when she got pregnant was before she turned 18. So that is, you have to be at an alert of knowing LMP and USG, because then you will be able to find out and you have to then report. So what can be done? Confirm identity, confirm date of birth, age of fruitful intercourse, take history, address, cell number, who has brought the girl or the boy to you, counsel or the guardian, and then decide married, unmarried, doesn't matter. Inform all cases to police. Call them either, or you inform them on your letterhead. Please take acknowledgement and see that an FIR is registered. And FIR has to be registered under section 154 CRPC, verify all documents, take deposition. This is what police do. They may arrest the husband or the perpetrator, and then the charge sheet will be filed. This is the police procedure. Can an MTP be done for this? Yes, you can do an MTP. Notify the police on your letterhead, take acknowledgement. Also tell the police if they want products of conception, because DNA can be extracted and the perpetrator can then be there's good evidence against the perpetrator. Consent of guardian for MTP. Collect and store the products of conception in normal saline. Label them properly. In the freezer, they can stay for 3 days. Hand over to the police and always take an acknowledgement. A lot of people will tell you these shortcuts for POXO Act because it is mandatory reporting. Do not show OPD consultation. Police do not take information. It is consensual. She is the boyfriend about to get married, even if it is 17 years. Police will cooperate and they say you do MTP. We do not want anything. Refer the patient to civil. Please do not do any of this. This slide I have put for a no. Please do not do any of this. Nothing of this will help you. Always involve NGOs. The last slide is the only thing that will help you. But even NGOs or state commission or national commission people will not come immediately. So you only have to manage that child there. But above all the things, please do not do. Please inform the police, and all these things will not work for you. So it is a gender neutral act. Attempt is also punishable under POXO. Mandatory reporting under section 19. Penalty for default of reporting in section 21. And you have to examine and treat the victim. Treatment can be given, has to be given by all. Examination, if you have a lady RMP or a lady nominated by the head of the hospital. If you do not have the male RMPs, can refer. Female RMPs have to mandatorily examine and produce the report. The next act is Domestic Violence Act. As I discussed, even marital rape is considered here. So amongst the various domestic violences, you have physical abuse and sexual abuse, which is defined as a conduct of a sexual nature, such as to force sexual intercourse, forcing aggrieved person to watch pornography or other obscene material, forcibly using women to entertain others, any other sexual act, abusing, humiliating, degrading, or otherwise violative of one's dignity. So it is very clearly defined. And other than physical abuse, this act also entails verbal and emotional abuse and economic abuse. Who is covered under the act? All females living in a relationship, mother, sister, wife, widow, and partners. The only thing is a female cannot complain against a female under this act. The complaint has to be done by a female against a male. So, in a nutshell, if you see all these acts are there for the females. Our law system is very strong with respect to protecting the dignity of a female. Unfortunately, the implementation is maybe not good at times, and more unfortunately, females do not know that laws stand by them. That is another big problem. So जिनको मालूम होना चाहिए, ज्यांना माहिती पाहिजे की हे सगळं आपल्यासाठी आहे, अनफॉर्च्युनेटली त्यांनाच ती माहिती नसते. And that is the whole issue. Otherwise, there is a gamut of laws, so many of them, which are standing there to protect all females. Who can file a complaint? Any woman can file a complaint. A child can file a complaint. Mother can file a complaint with respect to or for that child, against whom a complaint can be filed. Any adult male member who is in a domestic relationship, relatives of husband or male partner, and it includes both male and female relatives. So a female can complain against a female relatives of a husband. To whom the information can be given? It can be given to a police officer, protection officer, a service provider, or a magistrate, and all these have been defined and nominated in the act itself. What is a domestic relationship? When two persons live together, it's called as a domestic relationship. It could be a consanguinity marriage, any type of marriage, shared household. At the time of complaint, at the time of application, they may not be living together, but still for a previous issue, the female can complain. Even if she does not have a right, title, or interest to the living household, she can still be in that domestic relationship and complain. There is provision of shelter home and medical aid. So the protection officer or service provider and police can take the female to shelter homes provided and give her medical aid. Who may file an application to the magistrate? Aggrieved person, protection officer, anybody, any person on behalf of the aggrieved person. And the duty of the protection officer and service provider is give all assistance to the woman who is the victim of domestic violence. What are the orders the magistrate may pass under such situations? Either the aggrieved person should go for counseling, she be evicted and removed and put in a shelter home. If necessary, these proceedings can be done under camera. The protection officer can provide for grant for monetary relief and grant custody of orders to, for example, the child to the mother or this aggrieved person, the custody of her to another person. Obviously, also there is provision to grant compensation and damages, and breach will entail offense, obviously, because it will be contempt of court, it will be punishable under the law. Now, this Domestic Violence Act is not in derogation with, but in fact, it is in addition to other sections. For example, Section 498A of IPC, which states that harassment done by the male or the relative of the male to a female, the wife, for dowry, etc. So this can be in addition to all the different sections of IPC, mostly Section 498A. And then there is a Form 1 domestic incident report. This report has to be submitted to magistrate through the concerned police station about what happened to the female who complained and the entire procedure, whether she was put in shelter home or what is happening. So this DIR reporting is mandatory. Next act is the Immoral Traffic Prevention Act, and if all of you have seen the movie Begum Jaan, is exactly what this Immoral Traffic Prevention Act 1956 is against. So we have to know what this is. What is trafficking? Why this word traffic has come? Trafficking means a trade or something which is traded in, and it refers to a criminal practice of exploitation of human beings, where the human body is used for some form of profit. It could be different types of exploitations, as we will see. Immoral Traffic Prevention Act, ITPA, the Section 5 very clearly includes that the word trafficking is procuring, taking, and even inducing a person for prostitution. Even attempt to procure and attempt to take or cause a person to carry prostitution is an offense. Difference between migration, smuggling, and trafficking. That is the reason why the word trafficking is used in this act. Migration means when a person moves from one area to another area, maybe within country, maybe outside country, and with or without consent, legally or illegally. Smuggling is essentially movement of material from one country to another country. So for smuggling to occur or become liable for people, it has to cross international borders. Whereas trafficking is movement of a person with deception or coercion, and especially for forced labor or prostitution or servitude, to use that person's body for exploitation. And displacement of a person, as I told you, exploitation of the traffic victim, and commercialization and exploitation and commodification of the victim. That is what trafficking is all about. Who is a traffic or offender, a recruiter or a conspirator, who is or coerced or with abuse of power used similarly, or a children or a minor who's less than 18 years, maybe 16, 17 years, who are found at the places where commercial sex activity or commercial sexting is happening. So all of them become victims. No, there are so many non-commercial sex activities for which people are trafficked. So even that part is covered in the Human Immoral Trafficking Act. Workers are, trafficked for so many reasons: slave, child labor, drug peddling, organ trading, forced marriages, mail or order brides, beggary, adoption rackets, entertainment and sports, camel racing, exotic dancing, and so many other things. So it's not just commercial sex activity. People are trafficked for so many different reasons. And where this trafficking occurs, it can occur anywhere. It can occur at streets, massage parlors, bars, brothels, vehicles used for transfers, for escort services, at so many, trafficking places where pornography is made or shown, and at all the places. Now, this is what Section 370 I already discussed before in IPC Prevention Act, and this using threats or force or abduction for trafficking for commercial sex activity. And exploitation shall include physical exploitation, sexual exploitation, slavery, servitude. So, as I said, it is a big act. It entails so many different things. Consent of the victim is immaterial because the act which is happening is illegal. So, for an illegal act, consent is immaterial, and that is why it cannot be a defense for all these people that it was done. Imprisonment for 5 to 7 years, and even a person who has utilized these services, whoever knowingly or reason to believe has trafficked or engages, will also be punished with 5 years. And this has been again revived or extended by Criminal Law Amendment Act in 2013 after the Nirbhaya case. In the Immoral Traffic Prevention Act, there are so many offences. I'll not read out everything, but keeping or managing or acting a brothel, allowing use of premises for a brothel, and earning of the prostitution using that, taking up consent or induces a person for prostitution, any adult is procured or inducement is made. So this we can skip. Detaining a person or a brothel, again, all these are offences under the act, which I will just fast forward. Rescue and search and closure of brothel is given in section 15 of the act. Any magistrate can give this order, and closure of the brothel is section 18, and search without warrant. So there is no need for the police officer to get any warrant and waste time. They can just go and close down all these brothels, and these are all the different sections which can be put for these trafficked adults and children who are put in the brothels, and people who are the offenders who are using this. Then there are also sexual offences. Unnatural, we have already discussed rape, we have already discussed assault and criminal force, but there are then these unnatural offences in 377. There is no concept of consent, because intercourse by a male on a male, or a female on a female, or a male on an animal, etc. This is what section 377 says. All this is a crime, and the punishment may extend to 10 years and also fine. And under the Immoral Traffic Prevention Act, other than that, there is also provision of Juvenile Justice Act, wherein you have a Juvenile Justice Board, child welfare committees, provision of shelter homes for destitute children, observation and special homes, and also there are a lot of schemes. So this is integrated child protection scheme by Ministry of Women and Child Development. It's a centrally sponsored scheme, in order to, through a government and social civil partnership, in order to see that these children who are rescued from the brothel, they are given good education and shelter. And there are so many goals, that objectives that ICPS scheme has, and it's a good scheme through which the central funding comes, and all these children are then managed. The next law is sexual harassment at workplace. Again, this is a very important law which came in 2013, and it came after a judgment from Rajasthan in a case of Vishakha versus State of Rajasthan. Sexual harassment of women at workplace, prevention and prohibition of Act 2013. Again, it is in addition to what is given in the Indian Penal Code, which you have already discussed. The Supreme Court acknowledged that the human rights violations do take place at the workplace where the women are working, and it infringes Articles 14 and 15, right to equality, right to life in Article 21, and right to practice any profession under Article 19 of the Constitution. The Vishakha judgment also reiterated that it is the employer's duty to prevent and prohibit acts of sexual harassment at workplace, and have a redress and resolution mechanism to prevent this. And then there was this law which was framed with the objective of prevention, protection, and redressal, the Sexual Harassment Prevention and Prohibition Act of Women. Now, there is the employees cast a duty on regular and temporary, and all the employees. Who's the employee? Everybody, directly or through an agent or contractor, with or without remuneration. The employment, whatever small business, whatever is there, that person becomes an employee. The employer can also be in management, supervision, or control, and the provision of these committees. I will skip few slides. The workplace is now extended. All government and owned and controlled establishments, private sector organizations, sports institutes, stadiums, dwelling place, all the vocational and educational institutions, hospitals and nursing homes also included. So all of you who have female staff working with you, staff more than 10, please constitute an internal committee for your hospital. Only you or your wife cannot be, one of you can be members. You have to have somebody who's expert in law or a lawyer as a member, a part of an NGO or somebody who's working as a social activist as a member, and all their names and numbers have to be displayed at a conspicuous place in your hospital. All those who have applied for NABH will realize this is a very essential part of application to NABH. So any place visited by or arising out of during the course of employment. So we all will remember that jokingly during a party slapped one of his secretaries on the butt, and she reported this case to the police, and police said that you were partying and this is not a workplace. But now the workplace thing is extended to all the places where, even the parties, etc. So you have to be very careful about this. And sexual harassment is defined as, a request for sexual favors or pornography, or making sexually colored remarks, physical contact, unwelcome or verbal abuse, etc. We will skip all this. You have to make this internal complaints committee mandatory for establishment employing 10 or more employees. ICC has to be appointed order in writing. At least half of the members ICC be women. ICC to prepare and submit an annual report to the employer and the district officer. So this is the internal complaints committee. You can have senior women. You can have 2 members experience in social work or legal knowledge, 1 from NGO. And local complaints committee has to be set up in every district. And this is for organizations having less than 10 employees, organizations that have to set up ICC, and you can directly complain there. For our hospitals, I think most of us have more than 10 employees. So please have your internal committee ready. We will skip a little slides. These are the different reliefs that can be provided once the complaint is there. Transfer the aggrieved woman or respondent any other workplace, grant leave to the aggrieved woman for a period up to 3 months. And this is what has to be determined: mental trauma, loss in career, medical expenses, income, financial status, feasibility of such complaints and installments. This is the employer's obligation: provide a safe working environment, display at workplace the penal consequences of sexual harassment. This is what we have to do in our hospitals: composition of ICC, grievance redressal mechanism, and the meetings which occur all the time. Then there are penalties if you do not have this internal working committee at your hospital. Failure to constitute an ICC, it is rupees 50,000 fine and cancellation of your registration. So please be very alert about this and do form this committee at your hospital or working place. This we have seen. So friends, there are so many laws. I try to bring in as many of them as possible, and sort of see that we know what we have to do in our practice as medical professionals and as good citizens around. But always remember, again I will repeat, ignorance of law is no excuse. So you cannot be excused because you do not know a particular law. And also a pat in the back is only a few centimeters away from a kick in the butt. So always remember this. Our practice as a medical profession is a double-edged sword. We are really walking on a very thin line. We have to know all the different laws, and we have to see that we follow all the different laws stringently. Again, Nashik IMA, thank you so much for including me in this fantastic webinar today. Very different, very hatke, and superb speakers. And I've been listening since morning. Amazing workshop arranged. So thank you so much for including me. If any law is left out, it's only because of want of time. But I tried to probably include all the different acts and all the different things in my talk. So thank you so much.
Thank you very much, sir. You have almost covered all the topics, right from the pediatric to the working woman's place. Thank you very much. There was only one question about the talk that in case of POXO, like the small children, if we find them to be abused sexually, and if the parents are not ready for the complaint, then
So you have to still complain. See, the section 19 doesn't say that. Yeah, I agree. Section 19 clearly says that you need to go and inform the police. Parents' consent is not necessary.
Yes. So whether parents are willing or not, and if all the gynecologist or any practitioner, if they found a girl less than 18 years and pregnant, then still whether married or not, still
Yeah,
the complaint
I
has to
will.
be given.
I will minutes and narrate one case from Pune,
Sure.
and this will clear everybody's doubt. So now what? There was this girl who was 17 years and she was pregnant. So she went to one of the gynecologists, our POGS members, and she called me and I said, okay, you need to give a complaint to the nearest police station. So she gave a complaint to the nearest police station, and all the procedure was duly followed. The police came for products of conception, everything done, and next day MTP was done. So she called me and thanked me. She said everything properly done. I took acknowledgement. I took consent of parents. Everything done. So we said, okay, wow, everything nicely done. No problem. After 3 days, the police went to the sonologist who did sonography for that girl. And now the police told the sonologist that you did sonography for this girl. You've issued a report which mentions the age of the girl as 17. And in your impression, you have written single live intrauterine gestation of some 6-7 weeks. That means you knew that she is less than 18 and you knew that she's pregnant. Why you did not inform? That means every person has to inform. And they said, we have come here to arrest you because it is a cognizable, non-bailable offense. So therein lies the problem. So every person, the sonologist also has to inform, because every person is cast a duty to inform. How we got out of the mess, you all know. It's called vitamin M. It works sometimes, it doesn't work sometimes. But a lot of vitamin M had to be given, and we came out through the situation. So everybody has to inform, irrespective of whatever.
Exactly. Thank you. Thank you very much, sir. And all the best for your candidature
Thank you
for
so much. Thank you, sir. Thank you.